My son filed a petition to have me declared legally incompetent. He told the court I was confused. He told them I repeated stories, that I forgot things, that I wasn't safe to manage my own life. He asked to be named my permanent legal guardian. What he didn't know, I am a retired federal judge, and I had been recording every phone call for 8 months. I arrived at the courthouse on a Tuesday in November at 8:45 in the morning. I wore the suit I had worn to my last day on the federal bench. Charcoal, well pressed, the one Diane had said made me look like I was about to rule against someone. I carried a leather satchel that contained 3 folders, 2 legal pads, and a copy of the petition Ethan's attorney had filed 6 weeks earlier. I had read it 41 times. I know that number because I kept a log. Bernardo Say was already in the corridor outside courtroom 7 when I arrived. He is 53 years old, former assistant U.S. attorney, now in private civil practice. He shook my hand and said, "Ready?" "I've been ready for 8 months," I said. He smiled. We went inside. Ethan arrived 12 minutes later with his attorney, a man named Curtis Webb, who specialized in elder law and conservatorship proceedings. Ethan was wearing a gray suit I hadn't seen before. He looked, I thought, the way a man looks when he has rehearsed sincerity so many times that it has become its own kind of expression. He saw me across the room. He had not expected me to be there. That was the first thing I had planned. If someone you trusted ever tried to rewrite who you are, stay with me, and if you believe silence doesn't mean weakness, consider subscribing. My name is Walter Greer. I am 73 years old. I served as a federal district judge in the District of Oregon for 19 years before taking senior status at 69. I have written opinions that have been cited by 4 circuit courts. I have never been reversed on a criminal procedure ruling. I am not, and have never been confused. I say this not as a defense. I say it because it is the foundation of everything that follows, and I want it stated plainly before the rest of the story complicates it. Diane and I were married for 44 years. She was a high school history teacher for 31 of those years, and she had the historian's particular quality of remembering context when everyone else was reacting to the surface. She died of pancreatic cancer 14 months before Ethan filed his petition. She was diagnosed in September and gone by February, which is the particular cruelty of that disease. It moves faster than you can adjust to it. We have 2 children. Ethan is 45, lives in Lake Oswego, works in commercial insurance. He has a wife named Rachel, and 2 children I have not seen in 11 months. Our daughter Faye is 41, lives in Bend, runs a landscape architecture practice. She is the one who called me in March to say, "Dad, something is happening with Ethan. I don't know what it is yet, but something is happening." She was right. I want to say something about Diane before I describe what Ethan did, because she is the reason any of it stings the way it does. Diane was not a complicated person in the way that phrase is often meant. She had no hidden motives, no performance of warmth that concealed something else. She was simply and entirely herself. She made decisions by asking what was fair. She taught her students by asking what was true. She loved her children by accepting who they were, including the distance between who they were and who they might have been. She knew Ethan. Toward the end she told me, "Ethan sees the house and the accounts, and the pension, and he sees what he thinks he deserves. He always has." I kept hoping he would outgrow it. I asked if she thought he would. She looked at me. She said, "Keep your paperwork in order, Walter." That was in January, 6 weeks before she died. I made an appointment with Bernardo Say in March. Ethan came to Portland in April, 3 months after Diane's funeral. He came alone. No Rachel. No grandchildren. He said it was a planning visit. He wanted to help me think through the estate, the house, what made sense going forward. He was attentive and methodical. And he brought a yellow legal pad. I watched him the way I had watched 1,000 witnesses on the stand. I noticed what he wrote and what he didn't. I noticed when he asked questions and when he absorbed answers without following up. A lawyer who doesn't follow up on an answer has already formed his conclusion. He asked about the investment accounts twice. He asked about the pension once. He asked about the house, its current value, whether the mortgage was clear, 3 times, in 3 different framings. He asked, at one point, whether I had considered whether the house was too large for one person. I said, "I've considered it. I've decided it isn't." He made a note. On the second morning of his visit, over breakfast, he said, "Dad, have you thought about who you'd want handling things if you ever couldn't, medically, financially? It's not morbid, it's just practical. I have a durable power of attorney." I said, "It names Bernard." He blinked. "Just once. But I had been watching witnesses for 19 years and I saw it." "Bernard," he said. "Your attorney?" "Yes. Not a family member." "No," I said. "Deliberately not." He wrote something on his legal pad. I noted the time, 8:47 a.m. I wrote it in my own notebook when he went to get more coffee. In June he called to say he was concerned about some things he had noticed during his visit. He said, I had repeated a story about Diane at dinner. He said I had forgotten, briefly, where I kept the spare key. He said he had noticed what he described as some disorientation during our walk on the second morning. I wrote everything down after the call. Every specific claim, every word he used. I had not repeated the story. I had told it to 2 different people on 2 different occasions, which is not repetition. It is social behavior. I had not forgotten where the spare key was. I had moved it deliberately, 2 weeks earlier, because the landscaper had access. The disorientation on the morning walk was me pausing to look at a red-tailed hawk in the oak tree by the corner, a bird I had been trying to photograph for 3 weeks. He was building a record. So was I. My daughter-in-law Rachel is 43 years old. She is organized, efficient, and has the quality of never saying directly what she means when she's uncomfortable. She says it sideways, through qualifications and softened framings, in a way that leaves her a way out if the conversation turns. She called me in July. She said she was checking in. She said the children missed their grandfather. She said Ethan was worried about me, carrying so much alone. She said that at my age and with my history, it might make sense to think about some support structures. What kind of support structures? I asked. Just someone to help with the day-to-day, legal and financial things. So you're not carrying all of it by yourself. I have an attorney, I said, and an accountant, and a financial advisor, and I am a retired federal judge who practiced law for 11 years before joining the bench. A pause. Of course, she said. Of course, Ethan just worries. About what specifically? I asked. Another pause. Longer. You've been through a lot, she said. I wrote Rachel, July 14th. Support structures, carrying so much, pivoted when pressed. Ethan worries. I sent the notes to Bernard the same evening. He replied, documented, one more, and we file the preemptive motion. I found out later, through the RCMP investigator's interview with Amber, which I was not party to but which Bernard summarized for me, that Rachel had been texting Ethan updates after our calls, not vague impressions, specific reports. Bernard read them to me. One message, sent the night of the July 14th call, read, spoke to your dad. He doesn't suspect anything. Played the concerned daughter-in-law card. He's softer than you think. Keep going. Another, sent in August. He mentioned Bernard again. We need to move faster before he files something first. I read those twice. The second time I didn't feel anything except clarity. They were not worried about me. They were on a schedule. I sent the messages to Bernard with one note, add to file. Between March and October, Bernard and I built something I can only describe as architecture. The first element was cognitive documentation. I underwent a formal neuropsychological evaluation in April, 4 hours with a licensed neuropsychologist at Oregon Health and Science University. The evaluation covered memory, executive function, language, attention, and processing speed. The report, which runs to 22 pages, concluded that my cognitive performance was in the superior range for my age group across all measured domains. I didn't tell Ethan. The second element was a legal capacity assessment, conducted by a separate evaluator in June. This document certified that I had full legal capacity to manage my financial affairs, make medical decisions, and execute legal documents. It was notarized and filed with my estate records. I didn't tell Ethan. The third element was a written record of my current professional activities. I had been serving as an adjunct faculty member at Lewis and Clark Law School since my senior status, one seminar per semester, federal jurisdiction. I had published 2 law review articles in the past 18 months. I had a letter from the dean. I didn't tell Ethan. Bernard also prepared a documented response to each of the specific claims Ethan would later make in his petition: the repeated story, the spare key, the disorientation, written rebuttals, with dates, with explanations, with supporting evidence. And there was one more element. In late May, after Ethan's breakfast question about the power of attorney, I began legally recording my phone calls with him. Oregon is a one-party consent state. Only one person in the conversation needs to consent to the recording, and that person was me. I recorded every call from May 22nd forward, 11 calls in total, running a combined 4 hours and 17 minutes. I transcribed each one myself, at the desk in the spare room, the morning after each call. I have always been a fast typist. Bernard read the transcripts in August. He called me after. "There is a call from June 14th, he said. 12 minutes and 40 seconds. Where Ethan says, 'I know which one,' I said. 'That one will end the hearing,' Bernard said. I had listened to that call 4 times before I transcribed it. Each time I got to the same sentence, I stopped the recording and sat with it for a while, not because it surprised me, because I needed to understand it before I could use it without letting it use me. He had said, 'You can't spend it at your age, Dad. It's just sitting there. What are you waiting for? What are you waiting for?' I thought about Diane, about what she would have said. She would have said, 'Write it down and let it go. Don't let him have the anger. That's the only part he wins.' I wrote it down. I let it go. I kept the recording. That was the moment I understood he had already counted me out. Not recently. Not after the stroke. Long before. He had simply been waiting for the right circumstances to act on it. I had given him 8 months to prepare. I had used the same 8 months better. That sentence, 'someone who's actually going to be around,' was the one Bernard flagged in August. 'That one ends the hearing,' he said. Ethan just didn't know it yet. 'He's going to file,' Bernard told me in September. 'The account access questions, the Rachel call, the framing. This is a conservatorship pattern. He's been building his case, but he's been building it for 4 months. We've been building ours for 6, I said. Bernard looked at his notes. 7, actually. Good, I said. If you've made it this far, thank you. This kind of storytelling takes time. Telling it carefully matters. If you're not subscribed yet, now is a good moment. And if this is resonating, take a second to like the video. It helps more than you'd think. Asterisk. Because what happened in that courtroom, what one recording did to a 31-page petition, is the part I haven't told you yet. I called my daughter Faye on a Sunday evening in October, 1 week before the petition arrived. She lives in Bend, 2.5 hours east. She knew something was coming. She had been the one to warn me in March, and I had been giving her quiet updates ever since, without specifying the full scope. It's going to be a formal petition, I told her. Conservatorship. Ethan will claim I'm mentally unfit to manage my own affairs. Silence. He's going to file that, she said. Not a question. He's already prepared to. Bernard expects it within 2 weeks. What do you need from me? An affidavit, if you're willing. Your observations of me over the past year. Specific instances dated if possible. I have notes, she said immediately. I had not asked her to keep notes. She had simply kept them the way her mother had kept notes on everything, because they were both people who understood, instinctively, that memory is unreliable, and documentation is not. 3 pages, she said. I started keeping them in April when he came to Portland. Send them to Bernard, I said. She sent them that night. Bernard called me the following morning and said, "Your daughter is thorough. She was raised by a judge and a historian," I said. The petition arrived on a Friday afternoon in late October, served through Bernard's office. It was 31 pages. Curtis Webb had done thorough work. The document included a psychiatric evaluation conducted by a doctor, Norman Fell, who had met with Ethan for 90 minutes, and had spoken with me by phone for 22 minutes before concluding that I showed indicators consistent with early cognitive decline. It included declarations from two of Ethan's friends who had met me at a family gathering the previous Christmas, and reported that I had seemed withdrawn and confused at points during the evening. I had seemed withdrawn at Christmas, because Diane had died 11 months earlier, and it was the first Christmas without her. The petition also included a financial argument, that I had made several investment decisions in the preceding year that Ethan characterized as impulsive and inconsistent with prior patterns. The decisions he cited: I had donated $15,000 to Diane's former school's scholarship fund. I had purchased a used upright piano for $3,200. I had begun a home renovation project on the back porch that he described as unplanned. The scholarship was in Diane's memory. The piano was because she had played and I wanted to learn. The porch renovation was something we had discussed for 3 years, and I had simply finally done it. I read the petition in full that Friday evening. I did not rush. I took the same approach I had taken with every document in 19 years on the bench. Read once for understanding, read again for structure, read a third time looking for what is absent. What was absent? Any evidence that Ethan had spoken to my physician, any evidence that he had spoken to my financial advisor or accountant, any evidence that he had actually observed at first hand and with witnesses the behaviors he described. He had declarations from 2 friends at a Christmas gathering. He had a phone evaluation from a psychiatrist who had never met me in person. He had built a thin case and dressed it in 31 pages. I wrote a 14-page response in longhand, which is how I have always drafted legal documents. Bernard received it Monday morning, made 3 edits and said, "This is the most organized response to a conservatorship petition I have ever seen." I was a federal judge, I said. "That helps," he said. The hearing was scheduled for a Tuesday in November. I called Faye on Monday evening. She had driven up from Bend that afternoon and was staying at a hotel 3 blocks from the courthouse. She offered to stay at the house. I said I was fine. I wanted the night to myself. "Are you nervous?" she said. I thought about it honestly. "No," I said. "I was nervous every morning of my first year on the bench. I was nervous the first time I sentenced a man to federal prison. I am not nervous about walking into a courtroom. I have spent 30 years working in with 8 months of documented evidence, and a retired federal judge as the opposing witness." She laughed. It was Diane's laugh. Quick, genuine, no performance. "Mum would have loved this," she said. "She planned it," I said. A pause. "She told you to get ready," Faye said. 6 weeks before she died. We were quiet for a moment. "Get some sleep, Dad," she said. I slept well. There is something clarifying about a thing being ready. The preparation was finished. The morning was just a proceeding. I will not describe the hearing in full, because some of it is still subject to proceedings I am not at liberty to detail. What I can tell you. Curtis Webb opened by presenting Dr. Fell's evaluation. Bernard objected to its admissibility on the grounds that the evaluation had not met the statutory requirements for a court-ordered assessment under Oregon guardianship law. The judge sustained the objection. Bernard then requested, as a courtesy, that Dr. Fell be permitted to speak briefly before his report was excluded. The judge allowed it. This was Bernard's idea, not mine. He wanted the courtroom to hear what Dr. Fell had to say before explaining why it didn't qualify. Fell spent 4 minutes summarizing his findings: indicators of cognitive decline, recommendation for further evaluation. Then Bernard stood up. "Dr. Fell," he said, "how long was your in-person assessment with Mr. Greer?" "We spoke by phone." "By phone?" "Yes. 22 minutes. You flew in from Sacramento for the hearing this morning, and you've now met Mr. Greer for the first time in person." I reviewed documentation. Documentation provided by the petitioner, not by an independent source. "Is that correct?" A pause. "That's correct. And in those 22 minutes by phone, Mr. Greer did not know he was being evaluated for cognitive capacity. Another pause. He was not formally notified of the specific purpose. No, thank you, Bernard said. He sat down. Dr. Fell's report was excluded. He left the courtroom 40 minutes later with his briefcase, and did not return. Bernard then entered our evidence: the OHSU neuropsychological evaluation, the legal capacity assessment, the law school letter, the published articles, Faye's affidavit, a letter from my accountant, my financial advisor, and my physician. He entered the transcript of the phone call from June 14th, which I had legally recorded under Oregon's one-party consent law. Ethan had not known about that recording. In the recording, Ethan said, among other things, "Dad, the investment accounts and the house together, that's over $2 million. You don't need that. You can't spend it at your age. You're just holding on to it. At some point someone needs to manage it properly. And it might as well be someone who's actually going to be around. Someone who's actually going to be around." He had not said this in support of me. He had said this because he had stopped pretending I was the point. He had stopped pretending I was still alive in his plans. When Bernard played the recording, Ethan's attorney put down his pen. I looked at Ethan across the room. He was looking at the table in front of him. His jaw was tight. He had gone very still in the way that a man goes still when he understands that the room has changed around him, and he is no longer the one who knows what happens next. I recognized the position. I had watched it from the bench for 19 years. It is the look of a prepared argument, meeting an unprepared reality. I felt no satisfaction. I want to be honest about that. I felt something more like the particular exhaustion of a thing that needed to be done and has been done. The judge reviewed the evidence for 4 hours, including a recess. She returned to the bench at 3:45 in the afternoon. She denied the petition in full. She noted for the record that the petitioner had not presented sufficient evidence of cognitive incapacity, and that the respondent had presented a notably comprehensive and well-documented record of his current functioning. Then she looked at me over her glasses. "Mr. Greer," she said, "it's good to see you again." "Thank you, Your Honor," I said. Ethan left the courthouse without speaking to me. His attorney spoke briefly with Bernard in the corridor. A professional exchange, nothing more. Rachel called me that evening. She said Ethan was upset. She said he had genuinely been concerned about me. She said it had come from a place of caring. I let her finish. "Rachel," I said, "I have a recording of your husband telling me that I can't spend my own money at my age and describing my estate as something that would be tied up if something happened to me. That is not the language of a man who is worried about his father's well-being." She didn't say anything. "I would like to see my grandchildren," I said. "That door is open. This one is not." I hung up. Bernard filed a motion for attorney's fees the following week, citing the frivolous nature of the petition given the documented evidence of my capacity. Ethan's firm was copied on the filing, standard procedure when a professional is named in a conservatorship proceeding that has been denied on bad faith grounds. His employer's compliance department opened a review. Bernard also filed a referral with the Oregon Insurance Division, noting Ethan's professional conduct in the context of the petition. Whether that leads to a licensing review, I don't know yet. Bernard says the division's timeline is typically 6 months. What I know: Ethan's firm placed him on administrative leave in December. His name appeared in a professional network alert that Bernard's assistant flagged. I did not seek that. It was simply what happens when documented bad faith enters the public record. I have not spoken to Ethan since the hearing. Faye came for Thanksgiving. She brought her partner, a quiet man named Gil who works in landscape design and has the good quality of being comfortable with silence. We sat at the table. Diane and I had bought at an estate sale in 1998, and we ate, and the piano sat in the corner of the living room like something still being decided. "Are you going to learn it?" Faye said, nodding toward it. "I've been learning it," I said. Slowly. "Mum would be terrible about it," she said. "She'd want to hear you play before you were ready. She'd sit on the bench and correct my posture," I said. We sat with that for a moment. Faye said, "He thought you'd just let it happen." "I know," I said. "He thought you were too tired, too sad, too old." He thought grief made a man manageable, I said. He forgot I spent 30 years watching men miscalculate. She looked at her coffee. Keep your paperwork in order, Walter, she said quietly, quoting her mother. Always, I said. I have thought a great deal about what Ethan was actually afraid of, not my incompetence. I don't believe that was ever real. I think he was afraid of his mother's death, and the finality it placed on his own assumptions. The house was always going to be sold eventually. The accounts were always going to move eventually. Diane's death made eventually feel like it had an address. He had decided that address was him, what he hadn't calculated. I had spent 30 years on the federal bench watching people make that mistake. The mistake of assuming that inaction is the same as incapacity. That a man who doesn't fight loudly isn't fighting. That a man sitting quietly in a courtroom in a charcoal suit saying nothing is not the most dangerous person in the room. I have received 2 letters since the hearing, one from my grandchildren. Not a formal letter, but a card, hand-drawn, that Ethan's older daughter made at school. It says "Miss you Grandpa" in green crayon across the front. Faye thinks Rachel sent it without telling Ethan. I don't know if that's true. I keep it on the desk in the spare room, next to the folder. The second letter was from a former law clerk of mine, now practicing in San Francisco, who had heard about the hearing through professional circles. She wrote 3 lines. I heard what happened. I am not surprised. You were the most prepared person I ever worked with. I was never not fighting. I was documenting. He tried to have me declared unfit. The record declared otherwise. If you've made it here, you already know this isn't a story about courtrooms. It's about what happens when someone decides you're finished. And you spend 8 months proving you haven't even started. If this story stayed with you, there are others like it in the playlist. Stories about trust, family, and the quiet consequences of underestimating someone who keeps records. Take your time.